We should have like the Chicago Bulls
yeah.
music and lights. But Mike is the outreach manager for the Montana Department of Labor and Industries Employment Relations Division. Mike provides education and outreach for all things under employment relations, including wage and hour law, employment relationships, construction contractor and independent contractor registration programs, workers' compensation insurance, and workplace safety and health programs. Please help me welcome Mike Horner.
Perfect, thank you, Andy. And you know, sometimes they save the best for last, and other times it's just the guy that goes last. That's what's happening right now. It's just the guy that goes last.
Hey, Mike, technically, I just want you to know that little guy right there is called an owl, and it follows you around, so you can walk all over.
Oh, good. I don't have to be in one spot. They used to, yeah, last week they kept me in one spot.
We had to draw a line on them.
Yeah. Just to say one thing about Liz is you guys are talking about elevator mechanics. I'm going to talk about prevailing wage law or public contracts. You want your kids to grow up to be an elevator mechanic, because on public contracts, it's $57 an hour.
Yep.
Holy cow. Here I am, the outreach manager. I know I chose wrong a couple of years ago. And so, perfect. So thanks for being here. This is a big commitment. You guys have had a big day, so it's happy hour somewhere, so let's get there. Let's see, where am I pointing this? Right there. Just so the Employment Relations Division, you know, our work centers around helping keep Montanans safe at work. And we also work awful doggone hard to make sure employers and employees are treated fairly and equitable in the workplace. So this is kind of just a shotgun of all the stuff that we do. Some of them have fancy logos, some of them don't. Today I'm going to talk about wage and hour law and some of the things that our Compliance and Investigation Bureau, that sounds scary, but what they see on a regular basis. And then I'm also going to talk about the independent contractor program. I am going to, there's one slide about prevailing wage law. We're going to talk about some labor standards as far as youth employment. But let's talk about safety. I just want to give a plug for our safety. So we have a few things, a safety and health consultation program. I mean, we got a lot of all-stars, but we have some all-stars that are certified safety professionals. We have epidemiologists on staff. We have industrial hygienists. It's a free service to go out to a business and spend a day or 2 days, whatever it may take, depending on the size and scope, to look at the facility, go over the policies and procedures. We're not OSHA. We're not the Occupational Safety and Health Administration. So we don't issue fines. We don't, write you up or tell them what we're doing. We give you a safety scorecard at the end of our visit, and then you or whomever will take that to elevate the health and safety of your employees and your workplace. So it's free. It's awful exciting. We did work hard on that logo. We like that one. So that's on the bottom left. We do a thing called Safety Fest. We've been here to Miles City and done Safety Fest before. That's free safety training. The next one's going to be in Billings in September. The one that I don't have up here is we also do free safety training for high school students, college students, and youth groups. I think it's a somewhat underutilized program, but we have two expert trainers that go and what they do is it's called an OSHA 10 training. So it's 10 hours of training, and you can have it in either general in construction, or you can have it in general industry. So these young men and women in high school, they can go and attend that, and then they get this OSHA 10 card that they can have and hold for the rest of their life. And they can put it on their resume, and they can put it on their applications and says, hey, I've been safety trained, and this sets me apart.
Yeah, I think that it's included. That'll get you some gaining ground and apprenticeship too.
It'll get you something, yeah. Workers' compensation, we had Mike Bart. Yeah, Mike was here this morning. Bart, Sue is here today, so we do that. We also have a Human Rights Bureau that they're quite good. Here's how to find us. We got happy, smart, friendly people at 406. I'm not going to read it at that number. Wage and hour law, anything with prevailing wage, labor standards. If you're more comfortable just emailing us, that's the email address. This is our website, dli.mt.gov. We got our own .com for all safety stuff. So that's Safety Fest and safety consultation and safety training for students, montanasafety.com. And then montanadiscrimination.com goes to our Human Rights Bureau.
And you know, they have a lot of trainings, a lot of online trainings. that
Which
are
one?
available. Human rights.
Yeah,
yeah,
Montana yeah, I aspire to be like them. And
Anti-discrimination.
we are going to be like them one day. Or at least the stuff that is underneath my domain. I worked really hard at that. Yeah, they're awesome. And at the end of it, I'll have my contact information. So if I'm happy to be your conduit to whatever your program that you may be interested in. All right, so let's get into some fun stuff. Wage and hour law. And we're going to look at some state law and some administrative rules just to keep it fun and light. But the first thing that we look at, or our team looks at, so what is hours worked? Okay. You know, rest and meal periods, there is no state or federal law that says that you're required to offer those. I mean, it's a really nice thing to do. It improves employee morale. It's been shown to do that. But generally speaking, a rest break of 20 minutes or less, that's going to be hours worked. We're going to pay those people just to sit down, take a break, whatever they want to do. Meal periods 30 minutes or more, and they're completely relieved of their duties. That's not going to be hours worked. Okay. We're going to look at an administrative rule here in a second, but I mean, we pay people to wait, we pay people to sleep. I mean, think, you know, EMTs, firefighters, that sort of thing. But generally speaking, if you're completely relieved of your duties and you can use the time for your own personal reasons, then that's not going to be hours worked. Okay. So let's just look at one here. Oh, yeah. So dli.mt.gov. I don't keep a lot of this stuff in my head, and so thank goodness it's on our website. But if you go there, we've got a handy dandy menu on the side. You're going to click hours worked, and then here we have all of them. And then we have explanations, and then we have, if you're so interested, well, I shouldn't say it like that. Here's some of the administrative rules, and we're going to go over one specifically here a little bit later. It's good to know what the rule says. I mean, yeah, an attorney or a group of attorneys wrote it, so it's not the best reading, but it's going to tell you exactly what you can and can't do. So here is Administrative Rule 24.16.1005. So this talks about off duty. It also talks about, so yeah, this is not an eye test, so don't try to read all this. But basically what I highlighted is, and this is for my purposes, so I could look smart, but completely relieved from duty and use of the time effectively for his own purposes are not hours worked. These were written in 1972, so a lot of the stuff's going to say he and his. Just, I mean that's what we were doing back then. Because when I started reading all this, it's like, wow, we are really into he and his, and it's like, what about the she's? You know, I mean, there's a lot of she's in this, but anyhow, 1972.
They and them.
Yeah, exactly. And just another example. I mean, like, are you on call or not on call? I mean, like I have a friend that works at the hospital in Helena. He's on call. We play golf together while he's on call. Guess what? He's not getting paid during that time because he's using the time effectively for his own purposes. So that's the two things to look. But if you have a question about it, just call us, email us, or go to our website. There's good stuff there. Montana's minimum wage is $9.20 here in 2022. Federal minimum wage $7.25. Montana law has, and we're going to talk about the higher standard principle here in just a couple slides. But Montana law we have a law that says whichever is higher, that's when we're paying. Next thing my group, well, they're not my group, but I work with them. But the next thing my group does, I mean, yeah, they do a bunch of math. I mean, so we're trying to figure out what we're trying to figure out. I mean, yeah, there's lots of acceptable ways to get paid, whether it's weekly or biweekly or even commission or salary. We're just going to do the math, and we're gonna work it. I'm happy I figured. Well, you told me where the.
And you just remembered.
Yeah,
Excellent.
yeah.
I'm so glad.
Because last week I didn't use it because I was like way up here. I was like Vanna White. I was all over the place. But now this is nice. I can cut down my steps. Not that I, But we're just gonna go through this and figure out, okay, did they meet the minimum wage or not? So obviously 2 of these did, and 2 of them don't. You know, a work week, establishing a work week is 7 consecutive 24-hour periods. That's another thing that we're gonna look at when something comes to our, I mean, that seems like a simple one, but when that stuff comes to our desk, we're gonna look at it. I mean, it's fine to start it whenever. I mean, you can start it on a Thursday and end it on a Wednesday. And if you're gonna change it, you should have a good reason why you're changing it, especially if it comes to our office. But that's what it is. It's 168 hours. And again, we're using that to not only determine is minimum wage being met, but overtime as well. Oh yeah, so let's talk about overtime. Yeah, depending on whether you're exempt or not, and we're gonna go over the exemptions. But yeah, I mean, I shouldn't be a little bit, yeah, like everybody knows this, but anything over 40 hours in a work week is gonna be time and a half. We do get this a fair amount. I mean, holiday vacation, PTO, paid time off, sick leave, those are not hours. Okay, we just had Memorial Day. I was selfish, I took the day off, took holiday pay. But theoretically, the rest of those next 4 days, I could have worked 40 hours and had 40 hours of straight time wages and then 8 hours of holiday. I don't get 8 hours holiday and some fictitious 8 hours overtime and 40 hours of straight time. So those are not hours worked. So let's talk about, weighted average overtime. So again, this is not an eye test. You can choose to look at this or not. You can look at me if you want. Although, no, look at this. Look away from me. That's why, that's why we have this light, right? I mean, I don't want all this attention. I've got a face for radio. But what happens when we have someone that gets paid 2 or more types of hourly rates? Okay. So what do we do in those situations? So in this example, so there's 2 acceptable ways to do it. So in this example, the worker 36 hours at $9.20 an hour, then they work 10 hours at $10 an hour. The first thing to do is calculate because we're going to pay them on weighted average overtime. First thing to do is to calculate the straight time wages. Forget about the time and a half. Forget about all that. We're going to figure the straight time wages. Then once we get the straight time wages, this is helpful. Then we're going to take those numbers and we're going to divide it by the total hours. Now we're going to get to a weighted average rate of pay. That way we're creeping towards what is the average, what is the weighted average overtime. So because what happens, like I used to drive truck and I worked in a warehouse, when I'm driving truck, they paid me a fair amount, but when I'm sweeping the floor, they didn't pay me as much. Well, guess when I used to sweep the floor? It was at the end of the week. Okay. So if I work 36 hours during the week driving truck, 10 hours, that'd be a lot of sweeping time, I guess, but anyhow. And then at the end of the week, my overtime was based off of my sweeping the floor rate of pay. No, that's unlawful. We can't do that. Okay, so it doesn't matter when the rates of pay happen throughout the week. You either need to do weighted average overtime, or the other way to do it is to simply pay overtime based off the highest rate of pay. So in this example, it'd be the $10 per hour. And I did the math here. This is my slide, and I got to make the numbers whatever I wanted to make them. Because when you do the weighted average overtime, it's $459.26. That's what would be due the employee. If you calculated the overtime based off the highest rate of pay of $10, it would be $461.12. So that's not a big difference, but there can be big differences. And so you, as the payroll person or whomever, you get to decide how complicated you may want your life.
Yeah, because if he's only a mechanic on the elevator for 2 of those hours and the rest of it he's sweeping.
Oh yeah.
You probably don't want to pay on that elevator wage.
Right. It only took me 2 hours to fix the elevator. I'm really good at stuff, so yeah.
You're not a great sweeper.
Yeah. So, we've got a weighted average overtime calculator on our website. go there, use it if you like. Well, no, not if you like. Either, I mean, it's either or. You're either going to pay off the highest or you're going to pay the average overtime. There's no other way to do it. Okay. The Fair Labor Standards Act, FLSA. So that's the thing that establishes minimum wage, overtime, other like protections for labor. And so what our group, whenever we have a case come to us or when we get asked to look at something, first we want to decide what's the jurisdiction? Who has jurisdiction here? Is it the feds, which is the which is the Fair Labor Standards Act, or does it fall to states? And so two things here. Enterprise means as a whole, that means all of us. Some of them are, in the name. I mean, like, Karen and I work for government and Liz. And so because we work for government, guess what? Everybody that works with me, they're covered under the FLSA. Annual sales of at least, annual gross sales, forgive me, of at least 500,000, that would put you in enterprise coverage. So we'll look at all the employees and we'll determine, hey, is everybody covered? And if everybody is not covered, then we're going to look at individuals and we're going to decide, okay, what individuals are covered? Those engaged in interstate commerce. So what's interstate commerce? If I take a phone call from our neighbor in South Dakota and they want to give me a credit card to stay at my hotel, that's interstate commerce. Or an email. I mean, that's as simple as it can get. And I'm going to share, so let's just go there. Anytime you have questions, just ask me. I'm happy to not answer. I mean, happy to answer questions.
So it seems to me like just about everybody would fall in line.
Yeah, I mean, I mean, there's we've had some, and I can't think of it, but there are some exceptions, but I would say easily 95% of all Montanans are covered under the Fair Labor Standards Act. But we have this thing called the higher standard principle. And so, I guess I just said this. So step one, we're going to determine the jurisdiction, federal or state. And step two, we're going to apply the higher standard based on the jurisdiction. And the higher standard, I put this up here for my benefit, but I think it benefits all, because the higher standard is the one that is most beneficial to the employee. I mean, it's easy when we talk about the federal minimum wage. Yes, $9.20 is higher than $7.25. That's easy, but let's look at this last example here. So in state law, Montana state law, a resident manager of a lodging establishment is exempt from minimum wage and overtime. Okay, so that's in our state law, in our Montana code annotated. However, as we just discussed on the previous slide, if I take a credit card from South Dakota, now I'm engaged in interstate commerce, and the federal jurisdiction is going to take over. In federal jurisdiction, that resident manager is not exempt from minimum wage and overtime. And so the one that is most beneficial to the employee is the federal one, and that's the one that applies. So if you ever get into those situations, and you just want, well, it doesn't matter. We all like the easy button, but if you just want help with it, call us, email us. I mean, they're happy, friendly, maybe not all the time like me, but I mean, they're happy, friendly, but they're there to help. And so reach out to us, please. So there are common exemptions to overtime, and so either to overtime or to minimum wage and overtime. So the common exemptions are the executive, administrative, professional, computer employee, outside sales employee. Those are the ones that are in administrative rules. These other things like human resources director, that's great if that's your title, but that doesn't necessarily mean you're exempt. That's just a title. So you have to pass a salary and a duties test. So it has nothing to do with it. Yeah, I'm the outreach manager, big deal. But am I exempt from overtime and minimum wage?
So you have to be paid so much salary?
Yeah, and so this is another, add this to the list I don't keep in my head. So if we go to our website, on the side, we got this menu again, common exemptions, we've ordered them there. But this is the administrative rule. And it goes into, says, okay, this is executive employee. So it doesn't matter if I'm outreach manager, but I gotta be compensated on a salary basis at a rate of not less than $455 per week. So that's the salary test. The duties test is whose primary duty is management of the enterprise in which the employee is employed, or whatever the rest of that says. So salary test, duties test, titles are nice, but it's not the determining factor. So Montana state law determines or dictates, that's kind of a harsh word. Yeah, Montana law tells you when you have to have wages due. I guess I just said the same thing 3 different times. So what are wages due? So Montana law, and we're going to look at one. Yeah. So if I'm still employed, which I am, and so you have 10 business days from the end of the pay period to pay the person. Okay, so that's if you're still employed. Separated from employment, that could be voluntary or involuntary. Okay, let's talk about voluntary right now. If I quit, I'm not quitting. I like this job. I like you guys. But if I quit, then law says that you have to pay me my final wages, which includes holiday, vacation, all that kind of stuff. You have to pay me at the next payday within the pay period that I quit, which is today, or 15 calendar days, whichever is less. Okay. What if my boss calls Karen and I am terminated? Time is it?
I'll hang up on him.
Okay,
I don't wanna take the call.
perfect. Don't take that call. So it's 4:15. So Montana law says in a termination situation, final wages are due immediately, within 4 hours of the termination or the close of business, whichever is less. So if they called and she took it and gave it, they would have 45 minutes to get me all my stuff. Okay. Pre-existing company policy, Montana law does allow for pre-existing company policies. Maybe a good idea in this situation. Maybe a good idea in a situation where we terminate somebody on a Sunday and the payroll manager plays golf and we can't get a hold of her. So you can delay payment of final wages with a pre-existing company policy. And the delay of payment can't be whatever you make it. It has to fall in to the payday within the term, much like the quitting part of it, the payday within the pay period that you terminated the person, or 15 calendar days, whichever is less.
So question.
And all this is on our website too. Yes, please.
Somebody gives 2 weeks notice and they've given their notice and the company just doesn't schedule them. So they have just left it hanging. Is it still the 15 days or the next pay period?
For all the hours that they work, then yes, it would be that. It's up to the employer if they choose not to schedule
They
them.
chose not to.
Yeah,
But
yeah.
they didn't say you're.
That would be kind of mean, but yeah.
Yeah, it would be a kind
Yeah,
of a cruel thing, but they still are within that policy.
exactly.
Okay.
So like, and that just jogged my memory of a question we had in Lewistown regarding overtime. And the question was, can employers, force employees to work overtime? Well, the answer is the employer can make the schedule 4 hours, whatever they want to make it. And so if, I work 40 hours a week, but if they came to me and said, hey, we want you to work 60 hours a week, then that's legal. And then I get to decide how awesome I want my life or not I want my life. But the same thing applies to that. So it's like, okay, we're not going to give you more hours, but now we got to pay you at the next pay period for 15 calendar days, whichever is less.
So your employee handbook could say, if we terminate an employee, we aren't gonna pay them until the next payday, the next scheduled payday or whatever.
You can say that, yeah. I mean, employee handbooks and policy
As long as
manuals.
it's in the.
Yeah, and if you're, it's always a good thing. It's always a good thing to look at those on a periodic basis to make sure they need refreshed. If I can do 2 things at once, I can. Well, not really. Let's stop talking. It's a good thing to do a refresh of that. But if there's any questions, if you want help with it, just call us or email us. Say, hey, we want to put this pre-existing company policy in there. Is this legal? And then we'll tell. And then these subject matter experts that I have back at the office. They rattle off these ARM numbers and MCA numbers, and they have the books and they look them up. But anyhow, we'll help you with that. We're happy to help you with that.
So can we make it a pre-existing policy today and fire Joe on Monday?
No, well, so you want to make it, well. So the investigators, I would just say the investigators, I mean,
Lots of revisions.
you could call that a pre-existing company policy because you made it on Friday and then you fired Joe on Monday. But we're gonna come ask questions. And if it's found out that
If it looks sketchy.
it was premeditated or whatever, yeah, then, we're not into sketchiness.
I mean, you still have to have, in Montana law, you still have to have a reason you let somebody go. You can't just pick a day of the week and go, okay, I'm gonna fire Ron Nemick because it's Tuesday. If you still have to have a reason why you fired Ron Nemick.
We can fire, in Montana, we can fire people without liability towards the employer. But to answer your question, then you
But you
don't,
still have to have a reason.
yes.
You just can't say, I wanna pick a day just because that works within that.
Tuesday's when we fire
15 days.
people.
Yeah.
Yeah,
You know, Tuesdays is firing day.
yeah, exactly.
It's firing day because Friday's payday.
Right.
Because
exactly.
Friday's payday, so I can pay them on Friday. I don't have to pay them on Tuesday.
Yeah,
But I mean, you have to have a reason.
There's a
to
cause.
Ron Nemick go.
Yes.
Because he's a dunderhead or he fell off a rope or did something.
and who's this Ron Nemick? Is he here?
I always use myself as an example.
So if I get fired, I know, I use the same thing. So if we both get fired, Ron, then happy hour starts early.
Especially when my boss is behind me. I use myself.
Karen, I see. Karen's gonna take over the presentation. Ron and I are out.
I have not answered any phone calls for the rest of the day.
Yeah. So, thank you. So withholdings, so what can employers withhold from employees' checks? I mean, so I'm not talking about, I mean, there's federally required, I mean, Medicare, Social Security taxes, that sort of thing. Damages, mistakes, and shortages. We have, so we have in Montana, we have the Montana Code annotated, which is law. We have administrative rules of Montana, which are enforceable as law. Then we also, Attorney General opinions are also enforceable as law, and we have 2 Attorney General opinions, and those are older. I think those may be from the 70s too. But they say that damages, mistakes, and shortages cannot be withheld from a paycheck. So if I work at the bar and I'm carrying, what do I care? A plate of Cosmopolitans. Yeah, instead of beer. I like Cosmopolitans. Plate of Cosmopolitans, and I drop that, they can't withhold that from me. But what if we have a pre-existing policy and they had me sign an agreement that stated otherwise? Well, that's unlawful. Anything that is in conflict with Montana law is unlawful. So even though I may have signed something that said, hey, I'm a kind of a klutz, probably going to drop something when I'm here. Take it out of my paycheck. That's unlawful, so you can't do it.
What if I saw my employee take money out of the till and they stole it from me? Can I take that out of their check?
That's what
You just let them go.
I was waiting for you.
Go and then take it out, find out
Because
We're definitely firing them. I don't want to take it out of their
You
check
have to
too.
have a report in first.
well, so this week, that last week, that question came up. And again, I don't keep a lot of this stuff in my head. And so I go right to the MCA. So I was
You
prepared.
brought it for me.
I was prepared. So MCA 39-3-205, payment of wages when employee is separated from employment prior to payday. So we talked about some of that already. But subsection 3, when an employee is discharged by reason of an allegation of theft. I won't read some of the others. Well, yeah, I'll just read the whole thing. When an employee is discharged by reason of an allegation of theft of property or funds connected to the employee's work, the employer may withhold from the employee's final paycheck an amount sufficient to cover the value of the theft if A, the employee agrees in writing to the withholding, or B, the employer files a report of theft with local law enforcement agency within 7 business days of the separation from employment, subject to the following conditions. This is much like, so I used to work in the golf business, and golf rules can kind of be like this too. It's like, okay, let's follow the decision tree here. And so subject to the following conditions is if no charges are filed, then, wages are due and payable upon the expiration of the 30-day period. If no charges are filed in a court of competent jurisdiction against the employee for the alleged theft within 30 days of filing the report with local law enforcement, wages are due and payable within expiration of 30 days. If charges are filed, that's the next section, if charges are filed against the employee for theft, the court may order the withheld wages to be offset by the value of the theft. If the employee is found not guilty, or if the employer withholds an amount in excess of the value of the theft, the court may order the employer to pay the employee the withheld amount plus interest.
Yeah.
So much like in golf, the number one, when we used to run a tournament, the first rule in making a rules decision in golf is you go to the rule book and you take the information from the people and you go to whatever, in this case, you'll go to, hey, okay, it's MCA 39-3-205, and you read it verbatim to people. And then that's how you make a ruling. And so, and these questions of theft, it was kind of dense in my head just a little bit. It's okay, yeah, we gotta file charges. Yes, 30 days, you got a competent jurisdiction. Anyhow, so all that was kind of bouncing in my head. But this is the rule. This is what you have to do. And the thing I was talking to our section manager, Amy Smith, yesterday about, it's like, okay, well, this says specifically when an employee is discharged by reason of an allegation of theft. So if I suspect somebody has stolen from us, but I don't discharge them, I don't get to withhold it from them. You have to terminate, or you have to discharge them because of theft, and then go down this path. And the reason the option is the employee agrees in writing to the withholding, or the employer files a report. We're just giving people options. It's like, hey, we've got a video camera that shows you stole it. You can sign this, and we can withhold it, or we can go the other way. What do you want? Everything. Bam.
What about in employer property, like uniforms that aren't returned?
It'd be the same thing. Yeah, it falls within the same.
Fall like that?
It falls within this too. Yeah. And the employer can, employers get to decide too. It's like,
So
there's a bunch of shirts with Mike on it, but we're not hiring Mike ever again.
There was a good question last week on this one too, and I'm curious if you got the answer for us. If you had erroneously paid somebody for, say, an hour of work that it turned out they didn't work because they left early that day, can you take that out of their paycheck, their next paycheck?
Yeah, yes. If you overpay somebody wages or expenses, you as the employer have the right to recover that.
Okay.
Yeah, absolutely. You can recover that with holdings. We don't have this in administrative rules or in state law, but it would be a nice thing to do. Say it was happening over a 6-month period, and they overpaid me. It'd be nice if they withheld it over a 6-month period instead of just
Take it all
at once and having me be in the negative and like, I don't have any money. So yeah, so good stuff. I got smarter.
It's a good slide.
Well, yeah, is it? Oh, thanks.
You get a lot of talk on it.
Oh, yeah, you do. All right, so prevailing wage law, or, the Davis-Bacon Act is the feds, is the federal act. It's just not Montana, but all 50 states, we're the little Davis-Bacon Act people. But it's any public contract, whether it's construction or non-constructive services, so think, elevator mechanic or janitorial service, but any public contract in excess of $25,000 let by the state, county, municipality, school district, political subdivision, there's a minimum wage and fringe benefit minimum that you have to pay the workers. And we have a whole section on our website about prevailing wage law. We have all the occupations, we have heavy construction, highway construction, non-constructive services, building construction, but it's the minimum wage and fringe benefit minimum that you have to pay workers. So why do we have this? I mean, this is to protect local labor markets. And so how does it do it? I mean, so we don't want the wage and fringe benefits to be a competitive advantage in public works contracts. We just don't. And so state of Montana, we set the bar of what it needs to be, the minimum. You can pay more of that if you want to. And there's a stipulation in there that 50% or more of the workers have to be Montana residents. So that protects our local labor markets too. If you deal in prevailing wage and you want more information, you know, I do because it gets a little bit twisty and turny. And I'm working on some online tools to, one, make it engaging as much as you can make a government website engaging, but two, to make it easy to follow. But in the interim, till I get that done, if you want more information, just reach out to me, and I'm happy to do a one-on-one or a group presentation about prevailing wage law.
Sounds exciting.
Oh, it's a scene. No, it's fine. I mean, but there's lots of prevailing wage jobs that get done. And yeah, elevator mechanic would have been a good thing to go into. Who's laughing? No laughing, Liz.
I have a job for you. Seriously, I have somebody who wants
Good.
them to go to work for her.
Montana laws on child labor mirrors the federal laws. That's a good thing because the Department of Labor, the U.S. Department of Labor's website, youthrules.gov, I don't think you could do it any better. I always point people to that. So, I mean, this is just a snapshot of the main screen that comes up. And so whatever you are, if you're the worker, if you're the parent, if you're the employer, if you're the educator, you'll click on one of these things and it'll tell you what you can and can't do based off of your age. Because there's X amount of hours that you can work during the school year. There's X amount of hours you can work during the off school year. You can start at certain times. I don't keep all this in my head because this is just laid out beautifully. So youthrules.gov, I'd highly recommend it. All right, that's wage and hour law.
Perfect, it's 4:30.
Did you like that? Oh.
You're doing great, you're halfway, it's 4:30.
Yeah, we'll see how we do here.
He's not standing near the clock at all.
No, I am watching the clock because, you know, I like to get out early too. Okay. All right, so let's see, independent contractor, but more specifically, it's the independent contractor exemption certificate. Thanks for being here.
Speaking of golf.
I know. Is it golf league tonight?
Golf league.
Are you kidding me? That's awesome.
Play hard, have
I
fun.
love
We
golf
will
league.
follow the rules.
You know, the best golfer is the one that has the most fun. Just know that.
Watch out for the
Just know
squirrels.
that. Because like I said, I used to work in the golf industry and people get all amped up about golf. I gave golf lessons for a long time. Hey, the one that has the most fun, I think that's the best golfer. Because when I have fun, I play pretty good. So yeah. Independent contractor, more specifically, independent contractor exemption certificate program. So first thing, let's just define, you know, who's who. What's an independent contractor? What's an employee? So this is purposeful. I mean, we call this is a common law test called an A/B test. And so I've got A and I've got B. And so.
You pushed the button for too long.
Oh, I did.
Push another button.
If I push it, oh, perfect.
He's gonna know that thing. You're gonna have it down pat.
Now I know tomorrow, and Cindy, if I just want to leave, I'll just push it too long and walk out of it.
Yeah.
It's like, that's it. A/B test, independent contractors, it's an individual, I mean, it's individual engaged in an independently established trade, occupation, profession, or business. B is they're free from control or direction over the performance of their service. Employee, this is out of the taxation part of the MCA or the Montana Code annotated, but I'm not going to read that whole thing, but it's like, basically employee, the organization has the right to control the employee. I mean, the ones highlighted, that's why I highlighted, either you're free from control, that's an independent contractor, or you have the right to control. I mean, like I've got plenty of latitude to do my job, but in the end, they do have the right to control me. Probably should do that more often. That's the difference. For these, this is from U.S. Department of Labor. I kind of like this one, but we're not going to spend a lot of time on it. It's not an eye test again. But I mean, employee, yeah, you're working for somebody else. Yeah, you get paid by the hour. We'll talk a little bit more about that. Yeah, you use the employer's materials, tools, equipment. You typically work for one person. Independent contractor, they run it themselves. They get paid when the project is done. They own their own materials, tools, and equipment. But we're gonna talk about here in a little bit why classification matters. So ICEC, that's the acronym for Independent Contractor Exemption Certificate. So here in the state of Montana, and let me say not all independent contractors are people that are in business for themselves. Not everybody needs this ICEC, nor would they need a workers' compensation insurance policy on themselves. Okay, and we're going to get, well, we might as well get right into it now. I mean, why keep delaying it, Mike? So this is, oops, get my buttons messed up. So, I mean, this is the definition. I mean, it's a person who regularly and customarily performs services at a location other than the person's own fixed business location. So away from their fixed business location. So as I said earlier, not everybody needs it. So if I'm a cabinet maker and I have a shop at my house, or if I rent one in town, and I never leave the shop, all I do is build cabinets, I don't install them. I don't need the ICEC. I don't need a workers' compensation policy on myself. I'm not required by law. I mean, it may be a good idea for me to have my own personal workers' compensation policy. But when we go away from our fixed business location and we have the opportunity to bring liability to somebody else from a workplace injury or disease that happens to me, then that's when we would need to have the ICEC or a personal work comp policy. So away from your fixed business location. And I'm not going to read that. Doesn't matter. So here's a bunch of, it's just a bunch of business structures that, I mean, I don't even really know what all of them mean, but I'll just be honest. But some of these may be in business for themselves, but if they like the cabinet maker example, I could be a sole proprietor. If I stay at my shop and don't interact with people and go out on the road and install cabinets, I can be a sole proprietor and not have to have an ICEC. But these are just, we do define it in MCA, that number. These are the people, this is a person defined. All persons in the trucking industry, regardless of the business structure, must have the ICEC or have a self-elected workers' compensation coverage, and that's the MCA there. If you have questions, just reach out to us with specific examples of what's going on, because I don't want to say, I'm not going to categorize it. For me, it gets who needs it, who doesn't need it. But the most important thing in my head is like, if I'm working away from my fixed business location. Did I say that enough? Fixed business location, excuse me. So here it is. So we have an administrative rule of Montana that defines defines a fixed business location. It's the actual location where the majority of the business work is being performed. So I mean, it's more than a place to store inventory or product samples. It's where I actively engage in my work. So we have 23,000 approved independent contractor exemption certificate holders in the state of Montana. 65% of them work in construction. Makes sense. I mean, where are they doing the majority of the work? It's at my house or your business or something. They're away from their fixed business location. Their truck is not their fixed business location. So I did email this to you guys. So I just peppered this in here because I borrowed this, I borrowed with pride. I stole this slide from somebody else. But who needs it, who doesn't? I mean, the required, that's all those business structures here. Again, if they're away from their work. But over here, there are some exceptions, like corporate officers and managers of manager. So it's 20%, or if they own 20% or more of the shares, that or the business, that's for corporate officers in this group. But If in doubt, just call us, email us. It's easy stuff for our subject matter experts. More difficult for me. Thank goodness for other people. Okay, so what does the ICEC do? So what it does, again, the highlighted parts, that's what we're going to read, or I'm going to read. So if somebody has an approved ICEC, their status is conclusively presumed to be that of an independent contractor. So if it comes to our office and they've got that certificate, okay, this person's an independent contractor, they're not an employee. We're still going to investigate, but they're conclusively presumed to be an independent contractor. The other thing it does is if they're working under an approved ICEC, they've waived all their rights and benefits to workers' compensation or to benefits under the Workers' Compensation Act, and is precluded from obtaining benefits. So that part's over for them, unless they get their own personal workers' compensation insurance. It's like, why would somebody have, why would they have the ICEC, and why would they have a personal workers' compensation insurance? Let's talk about the benefits. Let's just talk about the benefits here for a second. So what are the benefits? I mean, it depends on the audience. So for independent contractors, so this first bullet relieves the person of the responsibility to obtain a personal workers' compensation insurance policy. That may or may not be a benefit, quite frankly. I mean, if I'm a professional bull rider, I've only I rode a mechanical one once, and I rode it twice because I'm really competitive. But it's not a question of if you're going to get hurt, it's when you're going to get hurt. So I probably would want to have a personal workers' compensation insurance policy on myself. So, I mean, granted, different trades are more, dangerous than others. And so people can decide. So the second bullet is a true statement. It increases the opportunity to obtain work for an independent contractor, because let's just skip down to hiring agents. I mean, so hiring agents, they're trying to limit the potential liability that could flow to them. And a hiring agent can be a lot of different things. I mean, like me as a homeowner, that's, if I hire a roofer to re-roof, that's considered casual employment. So it's really not very likely for liability to flow to me. But if I'm a business owner and I hire a roofing contractor to roof my business, then it could flow to me. So as a business owner, I'm trying to limit the potential liability that could flow to me. So guess what? If I'm hiring you as a roofing contractor, I'd like to see either your ICEC, or I'd like to see your workers' compensation insurance policy. And all the people that are working for you, I want to see the same thing. So if you've got it, I mean, so you've got it. That's to be more specific. If you've got the ICEC, we give people cards that they carry in their wallets, and I'll show you where you can look it up too. We don't give people's badges or anything. But if you've got it, and it's like, hey, as a hiring agent, okay, that makes me feel good, because now either you've waived your rights, not either. You have waived your rights to workers' comp, or you may still have your own workers' compensation insurance policy. You're attractive to me and from a worker standpoint, because it's going to limit the liability that could flow to me. And, the other bullet point, it aids in the hiring process of determining if this person is an independent contractor. So, I mean, funny how forget things. Okay, hit that button. Let's just skip ahead here. So, so this is our application. So we have a 3-page application. 1 page is instructions, but this we're doing all the vetting process up front about, hey, you're applying for this. Okay, show us that you're in business for yourselves. And we have this whole list of things that there's a point system. So like if I'm a contractor, I could share with you my business name that I've registered with the Secretary of State. So that would show that you're in business for yourself. I could share with you my business bank account. I could share with you, what else? Inventory of my tools that I own. Those type of things that show that I'm in business for myself. We're collecting all that information. So as a hiring agent, that's going to aid in the hiring process. And it's not a test, mind you, either. It's not a professional license. And we're not checking to see how good people are. How good they are is how they do their work. That's still on you to do that. But we are checking all these other things. Are they in business for themselves? $125. If it's approved, it's good for 2 years. And the ICEC is only good for the trade, occupation, profession that's listed on the application. So if I'm a roofer and I apply for it and I get it, great. But then if I'm doing a concrete driveway and it's not approved for that. And so we do find those, and we're nice people. And we say, hey, call the office right now, get concrete finisher on your ICEC. Because without it, it's only good for these trades that you list there. Hired agents, employer responsibilities. Yeah. Employers are responsible for classifying their workers correctly and treating them accordingly. We're going to talk about that. It is unlawful to coerce employees to adopt independent contractor status to avoid all these obligations of workers' comp, unemployment, minimum wage, overtime, tax withholding. It's unlawful. You can't do it. And if you do hire an independent contractor, then don't, because we talked about control, independent contractors free from control. Employee has the right to be controlled. Just don't exert too much control. Because when we go out there, our inspection group, they go out there, they inspect about the 4 factors of control. And they ask a whole bunch of, well, it's not a whole bunch of questions, but they ask questions. It only takes one of these to endanger the independent contractor status. So the first one, direct evidence of control or the right to control the worker. So if I'm an independent contractor and Karen hires me to, what's something cool to do? Yeah, we'll just re-roof your house. But she told, but what's that?
That's pretty cool.
Yeah. But she tells me to show up at 8 and work's done at 5 and you get a 30-minute break from 11:30 to noon. That's controlling me. I decide, I'm an independent contractor. I decide when I work, type of thing. If she wants to train me when I get there, that's another. We see that one a fair amount too. It's like, why does an independent contractor who's a specialist in their field, why do they need to be trained on how to roof a house? That would be evidence of control. Furnishing of substantial equipment. If I list heavy equipment operator as my profession and I don't own a backhoe, I borrow Karen's, my hiring agent, to do work, that's control. I mean, I guess I wouldn't have to own my own backhoe, but I would have to show, hey, I went to the rental yard and I rent this. I just can't have my hiring agent, Karen, lend me her backhoe for me to do work. Method of payment. So I mentioned earlier, if you get paid hourly, that's more indicative of a employer-employee relationship. If you get paid at the end of the job or something else agreed, that's more an independent contractor. That could be a factor of control. An independent contractor could put in a written contract with their hiring agent, and it has to be initiated by the independent contractor, and we investigate that. But I, as an independent contractor, could put in my contract with Karen, the hiring agent, to roof her house. I could say, hey, I want to get paid by the hour. May not be a good idea. I've only roofed one garage in my life, and that took a Labor Day weekend and more.
Having an ICEC does not mean that they're good at their job.
That's exactly right. Yeah. Yeah. I mean, because we don't vet those type of things. I mean, we're not out checking people's work. And then the right to fire without liability. So that would be a factor of control, because as in an employer-employee relationship, we can fire somebody without liability. And an independent contractor hiring agent, if I'm the independent contractor, I've got the right to complete this roofing project for Karen. If she says, hey, I don't want you working here anymore, something in the contract, there has to be some kind of restitution for me, because I was banking on completing this job. And so the same thing with Karen, with me, I just can't walk off the job without some kind of liability, but financial liability. So the right to fire without liability is another factor of control. All right, we're getting close to what you ask. I know, I got to be more specific. It's happy hour soon. Well, it's already happening without us, but that's fine. Tips when hiring an independent contractor. Yeah, I mean, again, that control shows up a ton, and we investigate that. Written contracts, verbal contracts are enforceable as written ones, but I know verbally what I'm saying today, when I'm in Sydney tomorrow, it's probably not gonna come out the same way. I mean, I guarantee it won't anyhow. But anyhow, get it in writing. Obtain and check references to ensure that they're expert in their field of work. I mean, that's why a lot of independent contractors, and we'll talk about why they do it, but independent contractors do it. I mean, there's lots of pros to being an independent contractor. I get to have my own schedule and do what I want, but I'm also really good at whatever, roofing. And I want to be a roofer. I don't want to do all this other stuff. More tips. Okay, yeah, so contractor.mt.gov. We've got a search tool. So you can look up somebody's independent contractor exemption certificate status. It's always a mouthful. Or just call us. We got happy people there. Yeah, Lindy, Lisa, Jessica, Casey. Yeah, they're all happy. Ask for proof of workers' compensation insurance. Same website. We've got a spot there where you can look up, see if somebody has workers' compensation coverage. So you can do some work. You can also call the insurance carrier and say, hey, you know, they said that they have a workers' compensation coverage. Show me, please. So do your work on that. So why does any of this matter? It depends on the audience. I mean, so all this stuff are stuff. All these things are, employees are legally entitled to those under the FLSA. Okay, so if I'm a worker and I'm deciding whether or not I want to be an employee or do I want to go out on my own and be an independent contractor, you should know what the pros and cons are. What am I getting? What could I be potentially giving up? So these are all the things. I mean, as an employee, you've got the right to minimum wage and overtime. You have the right to unpaid job protected family medical leave. There's anti-discrimination, anti-retaliation protections. You've got workers' compensation if you're injured on the job. If you're employed, I mean, that's a state law. You have the availability of unemployment insurance. The employer pays half of my Social Security and Medicare taxes. So you should know what you're giving up or what you may be getting. From a hiring agent's perspective, why does it matter? They may just be wanting, well, not may, I think most hiring agents are just looking to limit the amount of liability that could go to them. So it could be more beneficial to them. It's like, I'm going to hire you as an employee and pay workers' compensation on you and cover you with all these other things, because that's less risky to me. Or it could be less risky for a hiring agent to hire independent contractors. They just need to do their due diligence and make sure they get the ICEC. So another thing, why does this matter? You know, one of the earlier slides said, you know, classification is the responsibility of the hiring agent or the employer. And so when workers get misclassified, and it happens, and we investigate it, and whether it's intentional or unintentional, it still feels the same and has the same effects. Misclassification can create an unfair competitive advantage because the hired agent that is hiring the independent contractor, they're not paying workers' comp, they're not paying unemployment insurance, they're not doing any of this stuff. And so if a hired agent hires an independent contractor, but then exerts a bunch of control on them and treats them as an employee, then that's where it gets bad, and that's where we step in, and we're going to ask a bunch of questions to make sure what the relationship is. We get these two questions a lot from independent contractors. So if I'm an independent contractor, the top one, and I mean, I've got this big concrete driveway, and if you've ever done concrete, you can't really do that by yourself. But who can I hire? So one, yes, you can hire employees, just cover them with a workers' compensation insurance policy. That's easy. Two, you can use leased employees from some staffing agency, because the staffing agency covers those workers with the workers' compensation insurance policy. I could hire another ICEC or independent contractor exemption certificate holder. I could hire them to help me on that job, but I'm treating them as an independent contractor. We've got a written agreement of what he or she is doing, what the method of payment is, you're bringing your own tools, all this, I mean, I'm not, there's no control that I'm going to exert over you. One that you can't do is the last one. You can't hire an ICEC and then treat him as an employee. Like the example earlier, show up at 8, lunch is from 11:30 to noon, you're leaving at 5, and I'm going to train you what to do. No, can't do that.
Can you hire a casual worker?
A casual worker, meaning like my brother, or just
Yeah,
a
the neighbor to come and sweep after you?
Yeah, so casual employment doesn't apply to the ICEC or workers' compensation. Oh, yeah, that's right, yeah, that was the example we used in Lewistown, like if I was gonna come and split wood at your house, like, that's casual employment, because we're just friends, you didn't hire me,
You can also come to my house and split wood.
is that right? Perfect, not good at it.
I will not come and help you split wood.
Okay. And then the other one we get, it's like, hey, I'm an independent contractor. Can my personal health insurance or commercial general liability insurance be used in place of workers' compensation insurance coverage? The answer is no. So, I mean, if something happens to him or her, I mean, Montana law specifically requires the ICEC or workers' compensation insurance policy. That has happened, and then just bad financial things on top of the physical and mental and emotional things that can happen with workplace injuries. It's just bad things that can happen. All right, here's where you can find us. Again, here's me. If you want to reach out to me, I'm happy to be your conduit to all this stuff. I can be happy and friendly from time to time, but there's more people here. Anyhow, this is where you find us. Any questions? It's 5 minutes till 5. You know, it's not exactly way early out, but well, yeah. Maya Angelou, the poet, said, people don't remember what you said or what you did, but they remember how you made them feel. So if getting out 5 minutes early makes you feel good, then remember that Andy had everything to do with it and not me. Okay? Thank you very much.
Oh, did it. Holy God, everybody. Thank you very much, Miles City, and for those of you who drove in from out of town, thank you very much. If you have income billings, if you have any questions for anybody, please feel free to reach out. We're gonna move on to our next location, which is Sydney.